Welcome back, ladies and gentlemen. Mr. Braden, further questions for Dr. Burnell?
Yes, Your Honor. Dr. Burnell and members of the court, I realize that I'm the last person examining a witness, except for Cross, before we bolt. And it is Friday, and I can see the clock, so we'll try to be brisk through the rest of the examination. If we could turn to page 6 of your report.
Okay.
And I believe also if you look at Plaintiff's Exhibit 1 again on page 3, I believe he talks on page 3 again at the top about the maximization of geographic compactness.
Correct.
Do you understand that to be one of the criteria that appeared in Exhibit 7?
No, that's not one of the criteria.
And how would that criteria affect the line drawing process in reality versus a simulation?
Yeah, so the directives from the criteria were to improve compactness over existing districts when possible, which is different substantively than Chen's programmatic algorithm, which maximizes geographic compactness. So again, this is one of those things that differentiates the comparison group is not what it should be, because it's different.
And it's a different that might have an impact.
Absolutely, it might.
Okay, let's move over to page 7. And that talks about Dr. Chin's treatment of splitting vote tabulation districts. Can you talk to us whether you think that's the same as appears in their criteria?
Right, it's also different from the legislative criteria, where they, quote, made a reasonable effort to draw districts with fewer split precincts than current legislative redistricting plans. Oh, I'm sorry. With fewer split precincts than the current legislative redistricting plan. And that is different from what Chen instructed the computer to do. And so that means that the comparison group is not comparable.
And in the reality of the line drawing process, frankly, how important is not splitting voting tabulation districts, VTDs?
Objection, Your Honor. There's nothing in the report that addresses that question.
I think if you're going to generally discuss his treatment of splitting VTDs, you've got to know whether or not it makes any policy difference one way or the other. It's just simply re-precinct.
VTDs do get split all the time, and it's one of the building blocks, and line drawers do try to keep them together, but that's often overruled, or you have to split VTDs generally to equalize population. That's kind of one of the main criteria that forces the splitting of cities, counties, and voting tabulation districts.
I'll ask you a question, and it's always a dangerous question. I don't know the answer to this, but I'll ask. Were you in the courtroom for the most recent, the witness that appeared before you, who was the town clerk in one of the counties in this area?
Yes.
And he talked a little bit about a municipal subdivision appearing that in fact keeping a precinct together would have split the municipal subdivision. Did you hear that testimony?
Yeah, I think I did.
And so, Dr. Chin, do you understand how his splitting precincts would have worked there versus municipal boundaries?
Yeah, it probably would have. Well, I don't know how it would have worked. How does his algorithm balance these competing principles? I'm not entirely sure.
Kind of a standard political decision that a legislature might make?
Absolutely, all the time.
Yeah. Can we go to the next paragraph? And he says, he again seems to, if I read this correctly, this next paragraph talks again about nonpartisan criteria. Can you just tell us what you explained in the next paragraph?
Yeah, Professor Chen claimed to be able to prove an overriding partisan intent. And again, I take serious issue with the ability of his method or Pegdon's or Mattingly's to do that at all. But whenever somebody tries to divine the intent of a map maker, and this happens in almost every case, it's incredibly hard, right? And if you haven't been around redistricting and seen people draw districts, just to understand all of the inputs that the legislature tries to take in, and it's impossible to deal with all of them, right? And so when you say, oh, the map maker must have cut this line for this reason, that's almost always wrong in my experience. I mean, there's no way of knowing, why it's this way. And I was here last Friday, and I saw some of Professor Cooper's testimony, and there was one where, a college was cut in half, and it turned out that was the boundary of the VTD, right? And so it's very easy to say, oh my gosh, they gerrymandered and they cut this college in half, and they were just keeping the VTD together, right? It had nothing to do. Maybe the map maker didn't even know that a college was there. They were just looking at the VTDs. So it's hard to do, right? There's a lot of stuff that goes on.
And if we could go over to page 8, I believe the first full paragraph, the middle paragraph, you have a discussion there of North Carolina comparing to redistricting in other states.
Yes. So North Carolina has one of the most restrictive processes because of the county grouping requirements. And so it's more restricted and more complicated than relative to other states that don't have these same strict requirements about county groupings.
And for states that have a legislative process that doesn't have some type of constitutional provision regarding partisanship, can you think of a state that has a more restrictive redistricting process, a more constrained redistricting process than North Carolina?
Not off the top of my head, I can't.
And you talk later in this paragraph what might happen a little further down. Maybe we'd look at the last, starting at the 5, the 5th line from the bottom. If you'd highlight that real briefly for us. And it's, what would happen if there weren't county groupings in the state? Can you estimate from your experience how this might work without them?
Sure. I really think that the Democrats are at a distinct disadvantage because of this rule. If the rule weren't there, what typically happens if the Democrat, both sides want to draw efficient districts. And so in order to draw Democratic efficient districts, meaning, you win by a relatively small margin, in order to do that, in a city, in any city, not just in North Carolina, but in any city, you want to take some of the population in the city and then blend that with some of the suburbs and maybe even out into the rural area, and you're almost certainly crossing a county line at that point. But that can't happen here in North Carolina, so that really puts the Democrats at a disadvantage right from the get-go.
And I'd like to bring up now, just shift gears a little bit, not first to fourth, just first to second here. Can we get a legislative exhibit 118? And I believe that's table 1, page 9 in your report. Could you tell us what this table was meant to illustrate?
Sure.
And how you created it?
Sure. This table, along with the next several tables, are trying to illustrate a point that has been made by other witnesses, but how concentrated the Democratic voting power is among in the most populated areas in the state. So here, for instance, I've taken the 7 largest counties according to population and provided the margin of victory of Hillary Clinton over Donald Trump. So for instance, in Mecklenburg, Hillary Clinton won by almost 30 points, right? So that's not, she didn't receive 30 points, she won by 30%, which is a huge margin. And you can see for all of these heavily populated counties, Hillary Clinton wins by double digits, sometimes in the 20s, and then of course there's Durham, where it was an absolute blowout, where Clinton won by nearly 60 points.
And can we go to Plaintiff's Exhibit 119? And is this another way of illustrating that same point?
Yes, so what I've done here is show, kind of count up the number of counties required by both Hillary Clinton and Donald Trump in the 2016 election to reach 50% of their total statewide votes in North Carolina. And so you could see that Clinton does this with only 7 states, right? So once we get to the 7 counties. Once we get to the county with the 7th largest number of votes for Clinton, which is Cumberland, you can see that the cumulative number of votes is 1.19 million, which is more than half of her total statewide votes of 2.2 million.
And if we could go to plaintiff, legislative defendants exhibit 120. Again, this is another effort to show the geographic disadvantage of the Democratic Party.
Correct. So this is the analogous table for the Trump campaign from 2016. You could see that it's not until there's 17 counties in Trump's winning side that he reaches half of his total votes in the state. So it's much more dispersed.
And then one more, legislative defendants exhibit 117. And what is that?
This is just a map of North Carolina, and it's coded red or blue. Red is if Donald Trump carried the county, and blue is if Hillary Clinton carried it. And you could see that Trump has more support across in terms of geography, but of course the blue counties are the more heavily populated ones as well. So he only wins by 200,000 votes statewide, but in terms of where these votes are, they're concentrated for the Democrats.
Okay, and then I'd like to go to exhibit 18, plaintiff's exhibit 18. And that's, I believe, Chen's figure on page 48. And we are shifting gears again here. Maybe we're getting up in the third here. And this is on page, I believe, 48. And can you give us your views? You have a discussion in that paragraph on this particular simulation, figure 8. Can you provide us with what your concerns are as this being the basis for saying the plans of outlying partisan gerrymandering?
Right. So again, I think it's important to remember that I think that Chen's comparing apples to oranges here, chickens to people, but even with that, some of the simulations, the enacted map is not an outlier at all. You could see for this one, for simulation set 2 in figure 8, the enacted map is at 42 Democratic districts, and the bulk of the seats from a simulations are just slightly higher than that. And the question is first, if he was doing it the right way, if he was using political maps, presumably everything would shift to the left. But even without doing that, even if he just did nonpartisan maps, but took the criteria, if his criteria more closely matched the criteria that the state used, the legislature used when they drew it, even that could shift this over, and then this wouldn't be an outlier at all.
Yeah. And unfortunately, we don't have enough time, but I walked through, there's a variety of other exhibits of Chen. Let me just walk through them real quickly. On page 77, exhibit 37, figure 20. That's page 77 of his report. You've got the same concern there?
Yes.
And exhibit 48 on page 93, same concern as to it not showing a real outlier?
Yes. So the enacted districts are in the gray clouds there.
So it wouldn't meet your definition of an outlier?
No.
Okay. Let me move real quickly about the question of political extremism. What do you understand? This is Dr. Cooper's report. So he seems to think that the part of this particular redistricting plan in the state led to political extremism. Can you just briefly summarize your part of the report here?
Sure. Political extremism or polarization is pretty clearly not linked to the redistricting process at all, as we saw even in Professor Cooper's cross-examination with the the op-ed that he wrote. He said that in that thing, which is that's the standard political science approach at the moment, right? Because if you compare the House and the Senate doesn't even redistrict at all, but they have they've been becoming more extreme, just like the U.S. House has. And there are other things as well, but we're running out of time. But
So you share his views in his editorial, but you don't share his views in his report.
correct.
And just one last piece, it seems that he's looking at describing the state as a moderate state in aggregation. Does that really make any sense to you?
No, it doesn't. I mean, it makes sense as much as, if we want to know in the aggregate, if it matters, then it does make sense. But the state, we're talking about legislative, we're talking about districting, and so we need to know about the component parts. And so, if you have, a bunch of boiling hot water and a bunch of ice water, if you mix them together, that might be a pleasant, temperature to take a bath in, but separate, right? They're obviously not. And so that's the problem, is he's mixing, reds with blues and saying, oh, the whole state's purple, but we don't know the distribution of ideology. That's the critical thing.
Let me go to Professor Pegden's report. Is his simulation something that you've seen in the political science literature prior to the last year or two or three?
No,
So there's not as extensive, is there any extensive peer review of this that you're aware of?
not that I'm aware of at all.
And at the various seminars that you've spoken at, has anybody discussed this that you're aware of?
No, I hadn't seen it till this case.
If I could jump over to, does Dr. Pegden have the same apples to oranges problem, do you believe?
Yes,
Does he have the same problem with using the wrong criteria?
yes.
Let me ask you about Professor Mattingly. Is he a political scientist?
No, he's a mathematician.
Are you aware of his approach prior to this case?
No, I hadn't seen. I had not seen his approach before this case.
And in the various seminars and conferences, the long list that you've attended and/or spoke at, did he speak at any of those?
No, this isn't. Like I said, this is new. These are new techniques.
And have you seen any peer-reviewed literature that's not extremely recent that uses this approach?
No.
Okay. All right. What's the limitations of a math approach versus an approach that included political science?
I think there is a problem, that there isn't necessarily an understanding of the traditional redistricting criteria and how the process works in general. And so math can solve lots of things, but again, I think the important thing is to take a step back and look at, can this approach answer the questions that we need to be answered? And I think the answer to that is clearly no.
Can any type of simulation comparing a nonpartisan map to a partisan map answer the question of what is too much politics in this political process?
No.
No more questions at this time, Your Honor.
Cross-examination, Ms. Stevens.
Thank you. Good afternoon, Dr. Brunel.
Good afternoon.
You gave testimony earlier about academic scholarship concerning the use of nonpartisan simulations to measure partisanship, correct?
Yes.
And you said that you didn't think that there had been any peer-reviewed political science publications. I'm sorry. I'll try to be slower. You said that you did not believe that there were any peer-reviewed political science publications using academics about using simulations to measure partisanship, correct?
I don't think that's what I said.
So what is your testimony about whether there has been peer-reviewed political science publications using nonpartisan simulations to measure partisanship?
I think I said, I mentioned the Chen and Rodden's article.
So you do understand that the Chen and Rodden article from 2013, that's a peer-reviewed publication, isn't it?
Yeah, I mentioned it in my direct testimony.
And that from 2013 uses simulation techniques to measure partisanship.
That's why I mentioned it in my testimony.
Okay. And then are you aware that Dr. Chen has another paper from 2015, it's also peer-reviewed, that uses simulations to measure partisanship?
I'm not aware of that, no.
Can we call it Plaintiff's Exhibit 1? And can you go to page, I think, 180? All right, and you see there's a paper there from 2015 in the Election Law Journal? That's a peer-reviewed journal, isn't it?
That is a peer-reviewed journal, correct.
And that's a paper that uses nonpartisan simulations to measure partisanship?
I don't know what it is. All I see is the title.
You don't know. And then you see there's another paper from 2016. Can we go to that, John? Evaluating partisan gains from congressional gerrymandering using computer simulations to estimate the effect of gerrymandering.
Yeah, I see that.
Electoral Studies is a peer-reviewed publication.
It is.
Okay. And then you see that next paper from 2017.
Yes.
And I'll represent to you that that paper has now been published in the Election Law Journal.
Okay.
Another peer-reviewed paper using computer simulations to measure partisanship.
I don't know what that paper does. All I see is the title.
Okay, so
But
you,
Election Law Journal is peer-reviewed.
okay. And I don't know if you were here for this, but we heard testimony that Dr. Pegden's paper published in the Proceedings of the National Academy of Sciences, that was peer-reviewed by a political scientist and a mathematician before it was published. Were you aware of that?
No, I did not. I did not hear that testimony.
Okay, so you just, when you made your statements about peer review, you just weren't aware of the papers that we just discussed?
I wasn't aware of those papers. I mean, the fact that a political scientist was one of the peer reviewers of a math paper doesn't really mean anything.
And you said that you'd only been aware of this, familiar with the simulation techniques since around 2017, correct?
Since for litigation, that's when I kind of moved from when I knew about what Chen and Rodden did to when I started seeing it in litigation.
Okay, but we just established that there have been peer-reviewed publications on this topic since at least 2013, correct?
Yeah.
Okay. And you also said you thought the simulations weren't ready for prime time, right?
Correct.
Okay. Can we pull up the Pennsylvania Supreme Court decision? This is 178, A3rd, 737. And you're aware that this is a case in which a state court found that a map was an unconstitutional partisan gerrymander?
Yeah, I think yes. I'm
Okay.
aware of that.
Can we turn to page 818? And you see the court there says that perhaps the most compelling evidence concerning the 2011 plan derives from Dr. Chen's expert testimony about simulated maps. You see that?
I do see that.
Okay, so that court thought the simulations were ready for prime time?
Maybe they should have had me. They needed my testimony on the other side for that one to tell them that it wasn't.
Mr. Braden should have put you on.
I don't know why he didn't.
Can we call up the North Carolina Raleigh-Wake Citizens case? It's the Raleigh-Wake Citizens versus Wake County Board of Elections, 827 F3rd 333. Let's go to page 344. And this is a case from 2016 from the Fourth Circuit.
Okay. I'm not aware of this case, I don't think.
You're not aware? Okay.
No.
And you see there the court relies on Dr. Chen's simulations. Oh, sorry. Let's go to the middle paragraph on the right. You see there that the,
I think you want the next paragraph down, I think.
no, I
Oh.
think, yeah. The district court criticized Dr. Chen's simulations because the district court thought that they didn't ignore partisanship. You see that?
Okay, I see that, yeah.
And the Fourth Circuit said that the critique misses the point.
Okay,
Okay. So the court there thought the simulations were ready for prime time.
I guess so.
Okay. Dr. Brunel, you mentioned this on direct, but you testified on behalf of the defense earlier this year in the Ohio A. Philip Randolph Institute versus Householder case in federal court.
I did.
And that was also a partisan gerrymandering lawsuit.
Correct.
And you were there to criticize simulated maps created by an expert for the plaintiff.
Among other things.
And the court found that your criticism of the simulated maps, quote, seems to miss the point.
I don't recall what they said. I know they took issue with some of my points. I don't know if that was one of them specifically.
Can we call up plaintiff's exhibit 1017? Go to page, this is the decision in that case. You see that?
Yes.
Can we go to page 57? You see the court says, we further note that this criticism, along with others offered by Dr. Brunel, seems to miss the point of Dr. Cho's simulated maps.
I need to put it all in context, I'm afraid.
It says that, right?
Hang on. Yeah, but this is something specific that we haven't talked about here, which was about not perfectly equalizing population. Professor Cho, this was a congressional case where the standards for population equality are very strict. And in her simulation, she allowed the congressional districts to deviate by up to 1% for some reason, it was never clear to me. Well, it made her life easier. That was why she did it, so I get that. But it's the same sort of critique, right? These are on their face, these are unconstitutional districts that she was drawing. But this is different than the point I think you're trying to make, which is about the problem with the two comparison groups in general. And again, this court was unanimously stayed by the Supreme Court with this particular decision. So,
Dr. Brunel, when the Supreme Court stayed this decision, they weren't staying it because they disagreed with the criticisms that the court offered about your testimony, were they?
I don't know why they were staying it. I can't divine their intent.
Well, the stay petition didn't mention your name, did it?
I have no idea. But it was stayed nonetheless. That's the point.
It was, yeah. All right, let's go to, zoom back out and let's go to the footnote right there, footnote 621. You see the court there says, we do not give much weight to Dr. Brunel's report and testimony, and it found portions of your report unhelpful. Did I get that right?
That's what they wrote.
They said your report suffers from a scarcity of explanation, right?
Yeah.
And then the court excluded some of your testimony, didn't it?
I don't think so.
The court notes that Dr. Brunel offered a few new and previously undisclosed expert opinions at trial, and then the court says it's excluding that testimony because it was not substantially justified.
I don't know what they're saying here, but
Okay.
Everybody can read it, so
I read it correctly.
I think you did.
All right. Dr. Brunel, you haven't offered in your report any methodology for determining whether a map is a partisan gerrymander, correct?
I haven't, but there are methods out there, right? There are metrics, and again, up until the last couple of years, partisan gerrymandering cases, all we saw were measures of partisan symmetry. So the metrics do exist, and the problem with the simulation method, like I said, is it's answering a question, but it's not the question that we need to be answered, right? It's answering, did partisanship play any role in this map? And the answer to that, of course, in North Carolina was yes, it did. But it doesn't give us any other information besides partisanship playing a role, right? And so perhaps, so like I mentioned, I think what needs to happen, right, the improvements that need to be made are the comparison group needs to be partisan maps. They mentioned the nonpartisan maps as if this is a feature of their approach, and I think it's a bug. I think that's the problem. And so it needs to be improved on. And that's why I said I'm happy to see people like Professors Mattingly and Pegden jumping in on this because they have skills that and knowledge that political scientists don't have, and to the extent they can help us answer these questions, that's good.
And Dr. Brunel, we're really short on time, so I'd like to ask you to just really focus on the question.
Sometimes my answers take a little longer. I'm sorry.
It was a pretty simple question. You're not offering an opinion on whether the 2017 maps at issue in this case are or are not partisan gerrymanders. Is that right?
Wait, I'm sorry. One more time, really quick.
You're not offering an opinion on whether the maps in this case are partisan gerrymanders, correct?
That is correct.
Okay. All right. So, and Dr. Brunel, so you just testified that you think that the plaintiff's expert simulations are comparing apples to oranges because they're comparing the enacted map to nonpartisan maps, right?
Correct.
And you don't understand that Dr. Pegden's entire methodology is to make tiny changes to the enacted map?
I do understand that.
And he compares the enacted map to the new map at every step, right?
That's right.
And he compares the enacted map to other maps that are very closely tied to the partisanship of the enacted map because the comparison is made after every step.
I don't know if that properly characterizes what he does.
In fact, Dr. Pegden is comparing the enacted plans to other partisan maps, is he not?
No, he's not.
You just told me that you don't know what he does.
Right, but you mischaracterized what I think he's doing. Right, you're saying that you're testifying that he is using partisan maps, but he's not. Right, you need to draw partisan maps on purpose. You're saying maybe by chance he drew some partisan maps, therefore they're partisan. Those are very different things.
Dr. Brunel, what Dr. Pegden does is he makes tiny changes. He changes a VTD with using the enacted map, which is a partisan map, you would acknowledge, correct?
Partisanship played some role in the drawing of the map.
He makes tiny changes to the enacted map and he compares it at every step, meaning he's comparing it to other partisan maps.
But at some point they're not going to be partisan anymore. Don't you agree with that? If you make enough small changes?
Dr. Brunel, the truth is you just don't understand or know what Dr. Pegden
That's
did.
completely untrue. There are some things about his thing, particularly before he said his rebuttal, that I didn't understand because he didn't do a good job of explaining it, to be perfectly honest with you. And part of that is because we come from different disciplines, right? And so when he uses the term partisan bias, I don't think he used it in the way a political scientist did. So I didn't know what he was saying, right? And then in his rebuttal, he sort of, at one point he said, well, Professor Brunel could always just check my code. But I thought that was a very unhelpful, rebuttal. Sure, any of us can check his code, but most of us don't write the code that he writes. I wish I could, but I don't. So saying that I don't understand what he's doing is completely wrong.
All right, Dr. Brunel, you said in your report, didn't you, that you were confused about Dr. Pegden's analysis?
I just explained what I was talking about, yes.
All right. You said you're confused about the number of changes that happened before the new map is compared to the old map. Didn't you say that?
I did say that. Then he cleared it up because he didn't explain it very well in his original report.
Can you pull up Dr. Pegden's report? Okay. And can you go to page 5? And you see that Dr. Pegden, and if you can highlight under number 4, if you can zoom in on 4, quantifying intentional linked sets of use of partisanship. You see that Dr. Pegden says that one of the things his algorithm does at every step is to evaluate the partisanship of the districting resulting from the previous step. You see that?
Not yet.
See that under 2? Using historical voting data as a proxy for partisan voting patterns, he evaluates the partisanship of the districting resulting from the previous step.
Reading this, I'm not still I don't know if that's perfectly clear that he's explaining, I make a small change and I check.
Okay, so you read that and you didn't understand, this is what you said in your report, you didn't understand whether Dr. Pegden compared the new map to the old map after one step or after many steps.
Right, it wasn't clear how many changes were made before he made the comparison to the enacted map.
Okay, and this is Dr. Pegden's opening report, isn't it?
His what?
This is his opening report. It's not his rebuttal report, what we're
Oh,
looking at.
his original, yes, his original report, yes.
Okay,
But still, I don't, even reading that now, I'm not sure that that's perfectly clear.
okay. All right, you also state in your report that Dr. Pegden coins two new terms, fragility and carefully crafted.
Correct.
You state that you're not clear on what those terms mean.
Right, what's the bright line between just crafted and carefully crafted? Why does he create a new geographic unit that nobody's used before? It wasn't clear that there was a reason, there was a purpose for all these sorts of things. So yes, it was, again, these are, I had a month to read all these reports and respond to them. And Pegden's report, well, again, it's very sophisticated, and he clearly is a smart guy. But these are terms that redistricting people have, including me, haven't been familiarized with yet. And it's okay to create new terms sometimes, but that doesn't mean they're useful, right? So like when the efficiency gap came out a couple years ago, everybody was in love with it, and this was going to solve all of our gerrymandering problems. And then as people took some time to see what the efficiency gap, this metric, was all about, it turned out like every other metric, it too had problems, and these things were slow to come out. So same thing here, right? This is, I've never seen this before. He's made them up, and it's okay, like I said, it's okay to make up new things, but we can't just say, oh, this is perfect and this is solving all of our problems. Quite the contrary. I think we need to be cautious about it, and wait and see what people say about it.
All right, Dr. Brunel, you understand that Dr. Pegden had a section in his opening report entitled Defining Carefully Crafted?
I don't remember that, but I take your word for it.
Okay. And he also explained what he meant by carefully crafted in his testimony last week?
I wasn't here for that.
Okay. And you understand that Dr. Pegden has a section of his report in which he explains how he evaluates partisan bias?
I don't remember that offhand, but I'll take your word for it.
Okay. And you just don't understand what he means by those terms, and as a consequence, if the court needs to understand how Dr. Pegden measured partisan advantage in this case, you just don't have any helpful expert testimony to offer, isn't that right?
No, I think that's not right.
Well,
I think my expert testimony is, it was unclear to me, so I think it'll be unclear to other smart lay persons, non-mathematicians. And so that, I think that probably limits its usefulness, right? And maybe the court are all mathematicians and they get it and I don't, and that's okay with me, right? I'm happy to admit it. But yeah, it was, his report was more confusing than the other ones, right? And like I said, with the fragility, I understand what he's trying to do, but or carefully crafted, when's it not carefully crafted?
all right, Dr. Brunel.
You've had enough?
Perhaps. Dr. Brunel, can you flip to page 15 of your report?
Yes.
And you say in the paragraph at the bottom of the page, Professor Pegden chooses to use the results of just 2 elections for his simulations.
Correct.
And that was just wrong, wasn't it?
That's not wrong.
It's not wrong?
That's not wrong. He does some quick checks with other elections in his appendix, but he only uses those 2 elections for his full simulation.
Dr. Brunel, your testimony is that Dr. Pegden didn't use the 4 additional elections in his appendix to perform his entire statewide analysis?
He uses one particular metric, which I think was part of his analysis, but not all of it.
So Dr. Brunel, if in fact Dr. Pegden testified that he did exactly the same statewide analysis using all 6 elections, you would be wrong, correct?
I don't know if I might be partially, right? I might have partially misread what was in his appendix, if that's his testimony.
Dr. Brunel, in your report, don't you criticize Dr. Pegden for choosing only elections that, quote, have Democratic winners?
The two main ones he chose were Democratic winners, yes.
And when you said that in your report, you didn't say the 2 main ones. You said he only used elections that have Democratic winners. Isn't that what you said?
And that's true. In the body of his report, that's what he used.
You now understand that, and his appendix was on page 35, right?
I don't recall. I have no idea.
Did you read the appendix before you wrote your report?
Of course I read it.
You read the appendix.
I did not memorize all of the page numbers and what appeared on them.
You read the appendix before you wrote your report. You now understand that the appendix discloses that Dr. Pegden ran robustness checks using 4 additional elections.
Objection, I think she's mischaracterizing how he responded to the question and his understanding, or asking what his understanding is. That was more appropriate.
Dr. Brunel, you read the appendix. You understand that that appendix discloses that Dr. Pegden used 4 additional elections to perform his statewide analysis, correct?
Let me look at it. How about that might be useful?
Sorry.
So in reading this, on page 35,
All right, Dr. Brunel, I don't want to spend too much time on this. You said in your report, Professor Pegden chooses to use the results of just 2 elections for his simulations. And you didn't say that you were just talking about the first 34 pages of his report, did you?
Again, in reading this, it's not clear to me he does the exact same thing, right? He says, at the same time, I also test the robustness of our analysis to the partisan metric employed, in particular, apart from the random uniform swing metric, I will also consider the following metric. What is the Republican vote share in the 61st, or for the Senate 26th most Republican district? This simple metric captures how easy it is for Republicans to hold a majority. So that's where I thought it sounded like he didn't do the full analysis on it. So he did some robustness checks with just a partial analysis. That's what it sounds like to me.
I gotcha. Okay. You also criticized Dr. Pegden because you said that both of the elections he used had Democratic winners. You remember that?
Yes.
And that was wrong, wasn't it? Because 2 of the elections in his robustness checks had Republican winners, didn't they?
No, what I said is completely correct.
Dr. Brunel, 2 of the elections he used for his robustness checks had Republican winners, correct?
Right, but in my report, I said he only used 2 elections, both of which had Democratic winners.
Okay.
So I was right. I was not wrong.
All right. All right, Dr. Brunel, let's turn to Dr. Mattingly for a minute. You say on, let's pull up Exhibit Legislative Defendants Exhibit 291. Let's go to page 3. You say on page 3 of your report that Dr. Mattingly did not preserve incumbents. Correct?
Could you highlight it?
It's in the second paragraph. Incumbency protection is one of the adopted criteria.
Right.
You say it's noticeably missing from some of Dr. Chen's simulations and the simulations of Mattingly and Pegden.
Right.
And that was wrong, wasn't it?
No.
Dr. Mattingly runs an entire analysis in which he only considers simulated maps that avoid pairing incumbents to the same extent as in the enacted plan, doesn't he?
Right, but if you were here for my direct testimony, the incumbency protection is way more than not pairing incumbents. That's like the first step. That's a baby step in incumbency protection. It goes way beyond that. So I stand by that statement. It's completely correct.
Dr. Brunel, didn't you tell me in your deposition that you didn't understand that Dr. Mattingly preserved incumbents because he used the term avoiding double bunking in his report, and you didn't know what that meant?
No, that's completely wrong.
All right.
Wait, hang on. Let me finish answering it before you bring up the deposition. It's true. I'd never heard double bunking, but that's not why. I totally understood what he did, right? And he didn't preserve incumbents. And I had never heard that term before. The standard term for double bunking is pairing. That's what everybody in redistricting calls it. And so I'd never heard that term before. That's all that was exposed in the deposition. Nothing more.
Okay, so your testimony is that when you said that Dr. Mattingly did not preserve incumbents, you were just referring to the fact that he didn't do core preservation?
Right. The only things the simulations do is stop pairing incumbents.
Dr. Brunel, did Dr. Chen do core preservation in your opinion?
No.
Dr. Brunel, back on page 3 of your report, you say that incumbency protection is one of the adopted criteria and noticeably missing from some of Dr. Chen's simulations and from the simulations of Mattingly and Pegden. See
Okay.
that? And didn't you mean that incumbency protection was noticeably missing from some of Dr. Chen's simulations because Dr. Chen avoided pairing incumbents in his simulation set 2, but not his simulation set 1?
No, I don't think we can parse that to mean that.
No?
I don't think so.
I see. Why were you drawing a distinction there between Dr. Chen and Dr. Mattingly?
I don't know. I'm not quite sure why I was. I don't recall what was in my mind at the moment.
All right. But at this point, you acknowledge, of course, that Dr. Mattingly and Dr. Pegden did run simulations that avoided pairing incumbents.
They did.
Okay. And let's turn to the core preservation issue that you've brought up a couple of times. So you say that the simulations of the 3 experts who did simulations should have preserved the cores of prior districts to be fair comparisons to the enacted plan, correct?
That's one of several things that I think is noticeably missing.
But you have no idea if and to what extent core preservation was used in the enacted map, do you?
I don't know the number. I don't know the percentages for each district, but it was one of the criteria that was used, right? But I don't know. District 23 was preserved 88%, or the average preservation was X percent. I don't know those numbers off the top of my head.
Okay. Can we pull up Dr. Brunel's deposition, page 113? You see lines 14 and 15. You say, I have no idea if and to what extent core preservation was used.
Correct.
That's what you said in your deposition.
Yeah, that's what I said today.
Okay. Dr. Brunel, you don't know whether the map maker who was responsible for drawing the 2017 or the 2011 plans attempted to retain the cores of prior districts, do you?
I don't have specific knowledge to what extent that played a role.
Okay. And you did no work in your report to analyze the extent to which the 2017 or the 2011 plans preserved the cores of prior districts?
There was no reason for me to do that.
And you didn't do any work?
There was no reason for me to do that.
You didn't do that work?
I didn't because there was no reason to.
Okay. And you can't give us a bright line for what percentage of a prior district needs to be preserved in a new district to qualify as preserving the core, can you?
No, and it's, again, it's going to differ. The world it's complicated, of course. Sometimes there might be incumbents that don't want to preserve the core at all.
Mm-hmm.
You know, hey, all my voters are out here outside of my district, and I'll have a much easier time getting elected if I can include them and shed parts of these districts.
All right. And you agree that the adopted criteria don't specifically mention preserving cores?
I believe that's true, yes.
Okay. Can we pull up Plaintiff's Exhibit 588? And can you focus in on the incumbency protection criteria? And Dr. Brunel, do I have it right that you read that second sentence there to be a sentence about core preservation?
I think that goes beyond just not pairing incumbents, yes.
Okay. Can we pull up Plaintiff's Exhibit 603? You see that this is a transcript of the proceedings before the Joint Select Committee on Redistricting on August 10th.
That's what it looks like.
Can we turn to page 122? Can we zoom in on, exactly, thank you. And you see there that a senator asks Representative Lewis to provide clarification on the second sentence, the one that we were just looking at. And he says, more specifically, what is a reasonable opportunity to elect non-paired incumbents for either party? What does that entail?
Yes, that's what it says.
And then Representative Lewis says, thank you very much. I can interpret it the way I interpret it. If that's okay, there will be, and in fact, I think the press has written about, there will be pairings of incumbents that will not be able to be avoided in the drawing of this map because of other criteria. This is simply saying that the map makers may take reasonable efforts to not pair incumbents unduly.
That's what it says.
Okay. Dr. Brunel, core preservation can be a partisan criteria, correct?
What do you mean?
Well, why don't we just pull up your deposition?
All right.
Let's go to page 111, lines 20 to 22. You see there, you say core preservation could be a partisan criteria?
Yeah, that's what I said.
Okay. And you would agree that if a prior map has a partisan advantage for one party and cores are preserved, that could mean that the new map would also have a partisan advantage?
I could.
Okay. And you would agree that if a prior map is struck down as a racial gerrymander, preserving the cores of the prior districts could mean that the racial gerrymander could be preserved?
I think that's a bigger stretch. I mean, theoretically, yes, but I mean, I think that's a little. The connection is less clear.
It could
But it could be,
could
theoretically.
All right, and you do understand that the map that the 2017 plans were replacing were struck down as racial gerrymanders, right?
Certain districts.
Okay. Dr. Brunel, one way to achieve core preservation could be to preserve the cities and the towns that were in an incumbent's old district, correct?
That's kind of a less, I don't know, what's the word I want to use? It's related to it, right? But it's not exactly the same, but it can be related.
All right, Dr. Brunel. Let's turn to Dr. Chen. And you criticized Dr. Chen in your report for purportedly trying to maximize geographic compactness, right?
Right.
And you didn't review Dr. Chen's code before writing your report, did you?
I did not.
Okay. And Dr. Chen testified that his algorithm in this case wasn't trying to maximize compactness and that it equally weighs compactness, avoiding splitting precincts and avoiding splitting municipalities. So your criticism was just wrong, wasn't it?
No, I don't think so. So just because he gives equal weight to not splitting VTDs doesn't mean that his algorithm is different from what the legislature is trying to do, which is clearly different, right? The legislature, that's the key comparison, not what's the weighting of his algorithm with respect to splitting VTDs, but it's the question is his algorithm different from the legislative criteria? And clearly the answer to that is yes.
Dr. Brunel, you have no idea how the legislature weighted the various criteria like compactness for splitting VTDs, do you?
I know what's on the paper.
Okay. Dr. Brunel, you didn't do any work in your report to analyze what effect it would have had on Dr. Chen's conclusions if he had split more VTDs, did you?
No, I didn't do anything like that.
Okay. And Dr. Brunel, your report contains no criticism of how Dr. Mattingly applied the compactness criteria, does it?
I don't recall. I assume, since you're asking the question, the answer is it doesn't.
It doesn't.
Okay.
And in fact, you testified at your deposition that you didn't know how Dr. Mattingly treated compactness.
Okay.
And in fact, what Dr. Mattingly did was he took a look at the characteristics of the enacted plan and tried to create simulated plans that were comparable to what the actual enacted map looked like in terms of compactness and splitting precincts and the other nonpartisan criteria.
In terms of overall levels of compactness, is that what he was trying to match?
District by district, Dr. Brunel.
District by district. So District 12 in the simulation has the exact same compactness in all of his trillions of simulations as the enacted one.
Tried to make it comparable, Dr. Brunel. That's what he did. So your criticism of
Wait, what does that mean? He tried to make it comparable.
you don't know what he did, do you?
I don't think you do either. I mean, you're telling me what he did, but you don't. Tried to make it comparable. What does that mean?
Dr. Brunel,
Was it exactly the same or was it not?
Dr. Brunel, did you read the section of Dr. Mattingly's report where Dr. Mattingly, with respect to every county cluster, compares the compactness of the enacted plan to the compactness of his comparison simulated plans?
I read his entire report.
Okay. So Dr. Mattingly, your criticism of Dr. Chen for purportedly optimizing compactness or minimizing splitting VTDs, you just have no idea to what extent that applies to the other experts in this case, do you?
I don't think that's true. I don't know what you were trying to tell me about Mattingly. I don't understand. But I'm not going to withdraw my criticism of Mattingly just based upon that question.
Dr. Brunel, you just told me that you didn't criticize Dr. Mattingly at all for his treatment of compactness.
You just said that I guess you didn't say. You said that my criticism of Chen didn't apply to Mattingly. So if I didn't criticize him for that, then that's fine.
Okay. Dr. Brunel, you testified about the county grouping rules. You said they disadvantage Democrats.
Yes.
Okay. And you do understand that all of the comparison maps created by all of the plaintiff's experts followed the county grouping rules?
Yes, absolutely.
Followed the county grouping rules? All right. Dr. Brunel, you were an expert witness in 2011 in a case called Guy versus Miller in state court in Nevada, right?
Yes, I was.
And you were asked in that case to evaluate the partisan fairness of proposed state legislative maps in Nevada.
I was.
You were an expert witness for the Nevada Republican Party, correct?
I don't know if that's true. I think I was working for an interest group.
Can we call up Plaintiff's Exhibit 792?
But I honestly don't remember who it was, but
Sure. All right. And you see this is a court filing in the Guy versus Miller case?
it looks like it, yes?
Okay. And you see at the bottom of the page there, last two sentences, it says that the Nevada Republican Party hereby discloses witnesses who have been retained to provide expert testimony.
Yes.
Okay. Let's flip to the next page. And you see there that on page 2, you're disclosed as an expert witness on behalf of the Nevada Republican Party.
Yes.
Okay. And you're disclosed to provide testimony regarding the drawing of new congressional districts and new state legislative districts?
Yes.
All right. And then your report is attached, and let's go a couple pages further to page 1 of the report. Sorry, go back. See, this is your report provided in that case?
Looks like it, yep.
Okay. And can we flip to page 10 of the report? Can you go to the top there and highlight under partisan fairness? You see you were tasked with evaluating partisan gerrymandering in the proposed state legislative districts?
Yes.
Okay. And then you testified at a public hearing in Nevada in October 2011 regarding the legislative plans that you were evaluating on behalf of the Nevada Republican Party for this case?
Yeah, I testified at one point, yes.
All right. Let's pull up Plaintiff's Exhibit 793. All right. And Dr. Brunel, these are the minutes from the Nevada legislature of a public hearing on October 10th, 2011, to receive testimony concerning the legislative and congressional districting. You see that?
I do.
Okay. And can we flip to page 7 of this exhibit? And highlight the bottom bullet there. And you see that it says that the minutes reflect that you spoke at the hearing and you testified that the redistricting plans at issue systematically favored the Democratic Party.
Yes, I did.
Okay. And let's flip to page 17. And let's highlight where it says Exhibit H. And you see that the minutes disclose that Exhibit H, the minutes reflect that you provided a Microsoft PowerPoint presentation at the hearing titled Nevada Redistricting, Representational Fairness, and Racial Block Voting.
That's what it says?
Okay. And let's pull up Plaintiff's Exhibit 794. And you see there at the bottom, it's marked as Exhibit H to that hearing.
Oh, yes.
All right, and this is your resume, correct, as of that time?
Correct.
And let's go to page 5. And you see that this is the PowerPoint presentation you submitted to at the hearing in that case?
It looks like it.
Okay. And Dr. Brunel, when you were conducting your partisan gerrymandering analysis in the Nevada case, what you did was you took statewide elections and you did a uniform swing analysis to show how changing different levels of the statewide vote would affect the distribution of seats in the state legislature?
I don't recall, but that sounds plausible, absolutely.
Okay. All right, let's pull up Plaintiff's Exhibit 792 again. was your expert report. Let's go to page 10 of the expert report. And let's zoom in on that where it says 1, 2, 3. Yeah, right there. All right. And you explain that to see if a legislative plan is biased in favor of one party, you take one or more statewide elections, you break down the vote by the newly proposed districts. You see that?
I do.
And then you said that you calculate the overall percentage of the vote for both parties and the overall percentage of districts won by each party.
Yes.
And then you subtract or add 1 percentage point from the Democratic Party in each district, and you recalculate the number of districts, meaning seats, won by the Democrats?
Correct.
Okay. And that's the uniform swing analysis, correct?
That's right.
And you do that for the approximate range of 40 to 60% of the vote for the Democrats?
Correct.
Okay. Let's go to the next page, page 11 of this expert report. When you look at the top there, you say you use just 2 statewide elections. Is that right? The 2010 governor's race and the 2008 presidential election?
That's what it says.
Okay. Can you flip to page 12, please? See at the top there, zoom in on that. And you conclude there that the state legislative maps show, quote, heavy pro-democratic bias, correct?
Yes.
Okay. And that the legislative maps are unfair.
Correct.
And you reached that conclusion just based on your analysis of votes and seats in the proposed legislative map using uniform swing analysis based on a couple of statewide historical elections.
I don't know if I don't remember this report. This is all refreshing my memory. That's what we've seen so far. If that's all that's in the report, then yes,
Okay.
that's what it's based on.
Well, I could hand you a copy and you can take a look. It's not very long and confirm that.
All right.
I think it's 794. No, it's 792. I apologize. Sorry.
Thank you, sir.
And Dr. Brunel, I think if you'll look, there's some racial analysis in this report, and then the partisan analysis starts on page 10, and it continues until page 15.
Yes, that's what's in the report.
Okay, so you concluded that there was heavy pro-democratic bias in the state legislative map, correct?
Yes.
And you reached that conclusion just based on an analysis of votes and seats in the proposed legislative map, just using uniform swing analysis and statewide historical elections?
I don't know if I did other analyses that didn't go in to the report. This was a long time ago. It's possible that I looked at other elections and didn't include it, but that is what's in the report.
Okay. And you didn't compare the partisan bias in the legislative maps in Nevada to any other potential partisan maps, did you?
I don't know what you mean.
Well, Dr. Brunel, we've heard a lot of testimony from you here today that to evaluate whether something is a partisan gerrymander, you have to compare the enacted map to other partisan maps.
Right.
You didn't do that in this case, did you?
Well, you've missed the comparison again. So in this case, right, this wasn't a simulation method where I was drawing other districts, right? This doesn't draw any districts. Remember, this is whatever, when was it, 2011? So this technology, right, this approach didn't even exist. And so my testimony about the simulation method is that it needs to create partisan districts, not nonpartisan districts. And so the fact that I don't compare this to other districts, that's meaningless, right? This is just a straightforward, uniform partisan swing to look at what the seats votes curve looks like and how far it is away from the 50-50.
Okay, and Dr. Brunel, I understand your explanation, but just to confirm, you didn't compare the partisan bias in this map to any other potential map, right? You didn't compare it to other nonpartisan maps. Very simple question.
It's meaningless, though. I'm not going to. I don't know why it doesn't make any sense. Of course, I didn't, because that doesn't make any sense.
Okay.
So.
Okay. So right, to evaluate the partisan gerrymandering, you just used the hypothetical uniform swing based on the results of these statewide elections and the seats votes curve.
Correct.
Okay. Seats votes curve. All right, let's turn to page 11 of your Nevada report, which is, again, Plaintiff's Exhibit 792.
I'm there.
Okay, and it's page 11. And you say, that when the Democrats do have a simulated 50% of the votes statewide, they win over 60% of the districts. You see that?
Yes.
And you say this is clearly a pattern of partisan bias, i.e. gerrymandering.
Correct.
And that was your conclusion when you were representing the Republican Party in the Nevada case.
That was my conclusion for that case, yes.
All right. And let's go to Plaintiff's Exhibit 794. And let's flip to the slide entitled Representational Fairness. And you state here that the uniform swing analysis was, quote, absolutely conclusive in that both of these sets of districts are heavily biased in favor of the Democrats for both the Assembly and the Senate.
Yes.
Okay. Let's go ahead to the next slide entitled Partisan Gerrymandering. I think it's a couple slides ahead. And this is where you explain why your analysis is absolutely conclusive. Is that right?
I'm explaining why my conclusion is what it is.
And you say that you can be absolutely conclusive that there was bias, heavy bias, in favor of the Democrats because when Nevadans vote for Democrats at 50% of the statewide vote in each of the elections, the Democrats get 60+% of the seats.
There was an asymmetry in the districts as drawn.
All right. And then let's go to the next slide. All right, sorry, can you go back to the prior slide, please? And you say when each party receives a majority of the votes, they should receive 50% of the seats.
Yeah, I should have said they should receive a majority of the seats.
Okay. And then in the next slide, based on the same analysis, you say that the Nevada legislative plans would have been a leading candidate for gerrymander of the decade, right?
That is what I said.
Okay. Dr. Brunel, isn't it true that in the state of North Carolina, Republicans get 60% of the seats in the legislature with 50% of the statewide vote?
I don't know.
All right. Let's pull up. All right, let's pull up Plaintiff's Exhibit 362. Dr. Brunel, you recognize this as part of Dr. Mattingly's report?
Looks like it, yes.
All right. And you reviewed this for purposes of writing your expert report?
I looked at this figure, yes.
And you understand that the purple dots on this chart represent the enacted plan?
Yes.
Okay. And you see there that this is the Senate, right?
It is the Senate.
And you see there that under the enacted plan for the Senate, using the Lieutenant Governor 2012 election where the Republicans get about 50% of the votes. You see that?
I do see that.
And you see the Republicans get 31 seats.
Right, 1931, yes.
That's more than 60% of the seats in the North Carolina Senate, right?
Yes.
Okay. Let's pull up Plaintiff's Exhibit 365. You recognize this as figure 5 from Dr. Mattingly's report?
It doesn't say it on there, but I'll take your word for it.
And this is Dr. Mattingly's chart with respect to the House?
Yes, it looks like it.
Okay. And using that same lieutenant governor election, where the Republicans get about 50% of the state of the vote, you see that the Republicans get 72 seats in the House?
It's somewhere around there, yes?
To the left, it's to the left of that Republican supermajority line, right?
Right,
And the Republican supermajority line is 72 seats?
right.
Okay, and that's, so the Republicans got 60% of the seats in the House, right?
Okay.
All right. And let's do one more. Let's pull up Plaintiff's Exhibit 488. And this is from Dr. Mattingly's rebuttal report. It's a uniform swing analysis that he performed, actually in response to your report.
Okay.
See, you recognize that?
Yep.
And this is an example of uniform swing analysis using the results of 6 statewide elections, isn't it?
It looks like it is.
Okay. You used 2 in the Nevada case, and he does 6 here, right?
There was 2 in the report. I may have done more, but yes,
Okay. And again, the purple dots here represent the enacted plan. You see that?
that's my understanding, yes.
And the first vertical dotted line in each of these plots represents the line at which the Democrats break the Republican supermajority.
Yes, I think that it does.
Okay. So if the purple dot, which represents the enacted plan, is to the left of that first vertical dotted line, the Republicans have 72 seats,
At least,
and that's 60%.
yes.
All right. And you see that in each one of these statewide elections, when the vote is swung so that Republicans get 50% of the statewide vote, the purple dot is to the left of that supermajority line, meaning the Republicans have at least 60% of the seats.
It is.
Okay. And this is just using that uniform swing analysis. You don't even need any simulations to see that, do you?
That's correct.
And when you were testifying on behalf of the Nevada Republican Party, you said that a map that gave the Democrats 60% of the seats with 50% of the votes was a leading candidate for gerrymander of the decade, didn't you?
I did. I mean, but I didn't look at this for this particular case. This is outside the scope of what my report was about.
All right, Dr. Mattingly.
Brunel.
Dr. Brunel. In your report, you criticized uniform swing analysis as not reliable, correct?
No,
No?
incorrect.
Can we call up Dr. Brunel's report? It's Exhibit 291, Legislative Defense Exhibit 291. Go to page 4. He's there. All right. You see there that you say uniform partisan swing is also prominently featured in these comparisons?
Yes,
You say it's a standard method in political science, but it comes with baggage. You say it's a standard method in political science, but it comes with baggage.
correct.
And then you describe uniform swing analysis, and you say that the assumption there is not reliable. You see that?
Well, it's like any assumption, right? Assumptions, any model makes assumptions. And uniform partisan swing is a model. And like I explained in my direct testimony, I said that I say it's a standard method in political science, but understanding there are shortcomings, right, I think is important. There are shortcomings in me using it in Nevada, of course. There's shortcomings using it in any state. So, but it's like I think I said in direct, it's a useful tool. But understanding the assumptions it makes, I think, is important, right? Because the swing is very rarely uniform across all districts. That's what I said.
Dr. Mattingly, didn't you say, Dr. Brunel, didn't you say in the Nevada case that uniform swing analysis allowed you to be, quote, absolutely conclusive in stating that legislative districts were heavily biased in favor of the Democrats?
It was something, I don't remember the exact language, but that's close.
Okay.
Yeah,
That was the language, wasn't it?
yeah, that was pretty forceful.
That was what you said when you were an expert for the Nevada Republican Party.
That is what I said.
All right. All right. Let's switch gears. Dr. Brunel, you wrote a book in 2008 entitled Redistricting and Representation. You talked about that a little on Direct.
Yes,
And you wrote in that book that a voter who votes for a losing candidate will end up with, I'm sorry, you wrote in that book that a voter who votes for a losing candidate will end up with no representation?
I may have said that, but I think that was a little bit too much.
Well, maybe you didn't mean it, but you wrote it.
I think I remember you showing me the quote.
Okay.
Yeah,
Um,
I could have been a little bit more cautious.
But
with
you
my-
agree, at least sitting here today, that a voter whose candidate of choice loses will, on average, be less well represented than a voter who voted for the winning candidate, right?
Yes,
Okay. And you agree that the responsiveness of a legislator to the voters in his or her district is critical to democratic representation?
sure.
And you agree that the responsiveness of a legislator to the voters on questions of policy, in particular, is critical to democratic representation?
Yes.
All right. We've heard a lot about this trial about constituent services. Constituent services are one of the things that legislators do, right?
That's correct.
But in your view, they're not the most important thing, are they?
Well, in the book, I try to make our hierarchy, and I mentioned sort of the policy, how they vote on sort of the major policies of the day. I kind of put that at the top, and then there are other things that follow below. But constituent service is one of the things that every legislator does, and they do it to help their constituents, of course, but it also generates a lot of goodwill, right? This is something that legislative offices love to do because you can only make friends. You never make enemies helping out your constituents. So it's an important part, but if you're sort of, worried about the hierarchy of the things that they do, I think that how they vote on the major issues of the day is more important.
It's a higher form of representation than constituent services.
That's what I say in the book.
It's more critical. Policy responsiveness is more critical to the notion of representing someone.
I think that's what I say.
Yeah. And just as an example, if you're a representative and you cast a vote, say for gun control, you're not giving good representation to the voters in your district who don't want gun control.
Yeah, I think that's correct.
And that's just one example of the many issues for which policy responsiveness is the more central form of representing the people in the legislature.
Right.
Okay. And a change in the party that represents a given district generates a huge difference in the policies for which the representative of that district will vote, right?
Yes.
All right. Dr. Brunel, as we all know, this is a case about partisan gerrymandering.
So I've been told.
And you agree that partisan gerrymandering is a huge problem in modern redistricting, correct?
I assume that's a quote you're reading?
I'm asking you if you agree.
Yes, I agree.
You agree that partisan gerrymandering can distort how voter preferences get translated into public policy?
It can.
You agree that partisan gerrymandering can introduce bias into the political system?
Yes.
And you think partisan gerrymandering is important, a source of unfairness, and something that we should be worried about?
Yeah, I've been unequivocal about being against partisan gerrymandering.
And in fact, compared to other biases that you've discussed in your academic work, you've said that partisan gerrymandering is the most noxious form of bias in the electoral system, haven't you?
Well, you're sort of taking that out of context. That's compared to other forms of bias, which is, if you want me to give the answer, it's going to use the rest of your time. So
Well, that was my question. Compared to other forms of bias that you've discussed in your academic work,
Right.
it's the
but
most noxious form of bias in the electoral system.
It is, but we should talk about the other forms of bias, I suppose, if you want.
All right, you can do that on redirect. That's all I've got.
Let's take a 10-minute recess, resume at 4:20.
Mr. Braden, before we begin, let me just confirm that there's no cross-examination from interveners, the state, and Mr. Braden.
I will be prompt. Can you bring up, I believe you've seen some testimony from Representative Lewis. Can we bring up a little longer excerpt of Representative Lewis's testimony? This is Plaintiff's Exhibit 603 and page 119 and starting at line 9. Can you read that to the court real quick?
This criteria reads, reasonable efforts and political considerations may be used to avoid pairing incumbent members of the House or the Senate with another incumbent in legislative districts drawn in 2017 House and Senate plans.
And the next sentence, please.
The committee may make reasonable efforts to ensure voters have a reasonable opportunity to elect non-paired incumbents of either party to a district in the 2017 House and Senate plans.
How would that fit with your definition of preserving core incumbencies?
Right. So there he kind of talks about political considerations, and you can see that you could read that it goes beyond just pairing.
So, does it read pretty close to your definition of what would be preserving a core incumbency?
Yes, I think you could interpret it that way.
Okay. Let me go real quick to the case in Nevada. Do you remember this was, do you remember this was an impasse case?
Yes, it was.
Do you remember that's sometimes called a beauty pageant case?
That's correct.
Can you tell the court what that is?
Yeah.
Maybe unfamiliar with that term.
That's when there's no legal map drawn, and then it's up to the courts to draw a map, and of course the parties always have maps drawn for the court, and so it's everybody brings their favorite map to the court, and then the court picks their favorite map out of all of them,
Or draws their own map.
or draws their own map.
So it's beauty in the eye of the beholder.
Correct.
Okay. And then let me go a little quick. You remember the Ohio case? We've discussed it a little bit here.
Yes.
Do you remember that, and I'm not asking for a legal opinion, I'm really testing your memory here. Do you remember that the plaintiff's case was substantially based on the analysis from the Ruscio case?
Yes.
Same type of simulations to the best of your knowledge?
Correct.
And could we, if we've got it available, I think we might have a stay motion from that case that was granted unanimously by the Supreme Court. Could we bring that up? And let me represent to the court, I'm just bringing up this language, I'll represent to you, this is from a stay motion that we filed. I'll make sure we filed, maybe, that was filed in this case. If we could turn, there might be some familiar language here that we can turn to. Page 31, halfway down. And could you read that to the court?
The court credited a map simulation analysis in which an expert witness compared trillions of computer-generated maps against the enacted plan. But this was an apples to oranges comparison. The algorithm did not include the legislature's redistricting criteria. It did not preserve the cores of pre-2011 districts. It did not attempt to create majority-minority districts in Northeast Ohio or a minority opportunity district in Franklin County, or even attempt to reach a constitutionally required perfect equality of population. Thus, the 2011 map is an outlier as compared to the trillions of simulated maps, in the same sense that any particular person's IQ is an outlier when compared to the IQ of trillions of chickens.
You used the line more than one case?
Yes, I've used that before.
And to the best of your analysis memory, the simulated maps we're talking about here are similar to the simulated maps used in this case?
Objection, there's no foundation. And I would also note that, Mr. Braden is just reading a brief that he was into the record. I don't really think that's proper
think we'll sustain the objection to his attempt to compare simulated maps in one case to simulated maps in this case, overrule the objection as to the use of this petition for stay to the United States Supreme Court in the Ohio case.
Let me ask one more time, and I know that I'm keeping people from getting to the end of this case. Your memory is the case which they've cited to you where you weren't credited by the court was unanimously stayed by the Supreme Court?
Correct.
Thank you, Your Honor. No more questions. Oh, no, excuse me. Grab me and strangle me. But let me ask one final question. Based upon your expert opinion, have you seen any evidence presented in this case from which you, as an expert, could conclude that the North Carolina plan is a gross partisan gerrymander?
Objection, Your Honor. Dr. Brunel testified that he was not going to render any opinion on that subject.
Your Honor, they opened it up when they asked his opinion in regards to gerrymandering in other states. Seems that that opens up his view on gerrymandering here.
Sustained.
All right, you may step down.
Thank you. Thank you, Your Honor.
Further evidence for the defense? Two things, Your Honor. We are presenting a one witness by affidavit. That witness is Brian Deesby. He was on our witness list. We were told he works for the State Board of Elections. We were told by the state that he was out of town for this entire trial. So we obtained a short affidavit from him that the state signed off on in terms of the content of it. It is our Exhibit 315. And so we would intend to submit Mr. Deesby's testimony through that affidavit. It's simply what it states is essentially this court in Dixon v. Rucho had some language about precinct boundaries and how there's no standards for those and there never have been any standards. His affidavit simply reaffirms that that's still the case and was still the case in 2017.
All right. Is there objection to receiving that testimony by affidavit?
No objection to the affidavit, but we object to the characterization that Mr. Strack just provided of what the affidavit said, which we just don't agree with and is not in the affidavit.
Okay.
We'll read the affidavit. Right, we'll read it for ourselves. That's fine. So that's allowed.
And then we would like to move in some exhibits.
Yes, sir.
So the exhibits we'd like to move in are exhibits 1 through 22, 26 through 55, 91 through 93, 104 through 111, 114 through 116, 117 through 120, 121 through 140, 145 through 147, 150, 154 through 155, 159 through 160, 175, 183 through 184, 186, 190 through 191, 198, 220 through 221, 230, 239 through 242, 244 through 246, 259 through 260, 263 through 265, 278 through 286, 291 through 292, 315 through 326, group out of order, apologies, 61 through 71. And then we have a group that are for demonstrative purposes only. Those are 302 through 306, 327 through 328. And then a group for impeachment purposes only. Those are 297 through 300.
All right. Any objection to the admission of these exhibits?
Yes, Your Honor. We have a couple of categories of objections, but I think counsel just also read 291 through 292, but I don't think that was on the list of exhibits we were emailed earlier, so I'm not sure what those are.
We had mentioned that anything we used with Dr. Brunel was not on the list. That's Dr. Brunel's CV and his expert report, which I understand the court has.
No objection to those. I just didn't know what they were. So, Your Honor, I think just to be helpful, we printed out copies of the specific ones we object to, just so you can see what we're actually talking about here. So, Your Honor, the first bucket is exhibits 20, 21, and 22, which are three essentially expert reports submitted by Dr. Alan Lichtman, two of them in the Dixon case and one of them in the Covington case. We object to the admission of these reports for multiple reasons. One, most obviously, these are hearsay. Dr. Lichtman is not an expert for any of the parties in this case. None of the plaintiffs in this case were plaintiffs in either of those two cases. So it's just sort of classic hearsay, out of court statement by somebody. It's also undisclosed expert work to the extent they appear to be offering this as some sort of expert analysis on racial voting issues. Neither they nor us nor anyone else in this case ever disclosed Dr. Lichtman as an expert in this case. And along those lines, I would note, again, legislative defendants did have a voting rights expert who they retained to perform analysis in this case and who we were able to depose. And they chose not to present him at trial. That was their choice to make. But they can't then just sub in a report authored by somebody else in a different case who we never had the opportunity to cross-examine. And I can tell you they're offering this for their reading of the truth of the matter. We strenuously disagree with their interpretation of these reports, and that's all the more reason why you can't just admit out-of-court statements when there's no opportunity to cross-examine. And along those lines, I think this actually came up today. If you remember, we showed a book passage from Dr. Roden where he talked about North Carolina, and Mr. Farr said it well, where he said this can't be admitted for substance because Dr. Roden is not here for anyone to cross-examine. And that's the exact same thing here. We disagree with the way they interpret this report, and so it's just inadmissible hearsay and undisclosed expert work. I could stop there if you want to do argument on these.
Let's do these one at a time.
Sure.
Mr. Strzok?
Yes, Your Honor, thank you. It's simply ridiculous to think that we're trying to sub in Dr. Lichtman as an expert in this case. That just makes no sense. The court will recall from some of the testimony in this case that these reports were relied upon by the General Assembly in crafting the 2017 plans. They were referenced in the debates, and they are part of the legislative record, which none of the parties to date have disputed should come into the record in this particular case. So it's ludicrous to say we're trying to sub in Dr. Lichtman. We're not doing that. Obviously, it's part of the legislative record. It's stuff that the General Assembly clearly relied upon, and it should not be controversial that it be admitted into court.
May I respond, Your Honor? It simply can't be that legislators could get around all of the rules of evidence by just lodging a report that somebody else wrote in the legislative record, and they'll say as part of the legislative record so we can admit it for the truth of the matter. Dr. Lichtman didn't prepare this for the legislature. I mean, imagine the scenario where they could just pay an expert to come up with an analysis, lodge it in the legislative record, and then say, you don't get to cross-examine this person, but it's part of the legislative record, so we now get to admit it as substantive evidence. Yeah.
Okay. Let's move on to the next group.
The next one is Legislative Defendants Exhibit 244. This is Dr. Chen's report in the Common Cause v. Rucco case. And I might be saying that wrong. I always say it wrong. Rucco. If you recall, there was actually an objection that we raised when this was discussed because we had previously been precluded from asking about the 2016 congressional plan. And what opposing counsel said is, oh, we'll use this only for impeachment purposes, not for substantive purposes. So just for that reason alone, plus it's also hearsay, this is not admissible for substantive purposes, including based on the representation that was made at the time.
Your Honor,
Yes.
if I may be heard on that, again, I'll admit I probably don't have as good a memory as most people in this courtroom, but I do not remember saying that the only reason why we wanted to bring that up was for impeachment purposes. If the transcript says that, then I'll stand corrected, but that's not my memory. I asked the court to consider it and then rule on its admissibility later after you heard the testimony.
I'm not recalling the relevancy of Dr. Chen's testimony in the Covington case. Maybe you can refresh my memory.
In the Covington case, Dr. Chen did 3 sets of simulations. It's Rucco versus Common Cause, Your Honor. That was the report was in Rucco versus Common Cause. He did 3 sets of simulations. 2 of them were similar to what he did in this case, where he said he was using nonpartisan criteria as he interpreted it to do simulated maps. He said that, and he testified about this, he said that all of his simulations could always result in only 12 counties being divided. However, the legislature divided 13 counties. So he said, and he testified to this, to check to see whether or not the partisan bias that he found in the plan was caused by the legislature's decision to divide 13 counties, he ran a 3rd set of simulated plans dividing 13 counties. And the relevance of that, Your Honor, is that Dr. Chen did not do that in this case. Dr. Chen did not do simulated maps dividing the number of VTDs or dividing the number of municipalities that are in the 2017 enacted plans. He did not check in this case to see, for example, if the partisan bias he observed in the plans was caused by the legislature's decision to divide the number of VTDs they divided, as opposed to minimizing the number of divided VTDs, which was the criteria that Dr. Chen used. So that was the relevance of that testimony.
All right, so you're submitting this solely for the purposes of showing that in one case he did one thing and in this case he did something else?
Yes.
So for impeachment purposes, to bolster the question that you already, I mean, you're introducing an exhibit to
I think so, Your Honor.
okay. All right. All right, let's look at 245.
245 article written by Richard H. Pildis and Richard G. I'm going to get this wrong. Niemi, who, needless to say, are 2 people who not testify in this case. So it's just hearsay.
All right. Once again, Your Honor, the court looks at the adopted criteria. The criteria expressly relied upon the compactness levels specified in this very article. It's part of the record. It's part of what the legislature relied on, and that's why it should obviously come in.
All right. Thank you. next exhibit or group of exhibits?
Yeah, 278 and 279 are paired, they're just the House and Senate. These are exhibits that somebody with the legislative defendants prepared, but we have no idea because nobody testified about them on direct for legislative defendants by anyone. I don't believe. You know, there's like things in the middle columns here that say yes and no about, you know, Democrat, solid, or competitive. We have no idea. There's been no foundation for what those terms mean, who came up with them, what the criteria were. Same with the next two columns. I mean, there's just been no foundation or substantiation for any of this.
So, Your Honor, those were simply summaries of the testimony and other evidence that the plaintiffs have been in possession of for months. We provided part of it comes from the deposition of Morgan Jackson, which has been submitted, parts of it by deposition designation. We've provided the plaintiff with the specific page numbers and where we got the information from. Part of it is derived from the support scores and that information that we received from the Democratic Party. It's really under Rule 1006. It's simply a summary of existing evidence, voluminous evidence that we thought would be helpful for the court to have in a summary form. This is evidence that we could cite to if we wanted to in the briefing and just have a string cite and let the court try to piece together this document, that document, and the other document. But we simply summarize it in one document that would be easy for the court to review. So we think under Rule 1006 is clearly a summary and admissible.
May I respond, Your Honor?
Yeah.
This is what they characterize as a summary, but it's not a summary. It's their characterization. So, for instance, the middle column here that says Democratic, solid, or competitive, nobody has testified that these districts are Democratic, solid, or competitive using the metric that they're using of support scores. I don't even know. I mean, sitting here today, I literally have no idea. I mean, I can guess. I don't have no idea how they came up with those categorizations. Mr. Strack just said that they could cite to testimony if they need to. I think that's what should be done because we just don't agree that these are summaries. This is just something counsel prepared.
Your Honor, again, onto that specific point, the 47%, the light blue, came from the deposition of Morgan Jackson. So again, it's just using the information that's already in the record, summarizing it, and putting it in a form useful for the court.
All right.
The next two are 280 and 281, Your Honor. And I guess I'll just say I don't know. Nobody's testified to these percentages. Nobody's authenticated them. They may be right. They may not be right. I just have no idea. There was no witness put on to authenticate these or somehow validate them in any way. So for that reason alone, we object.
Your Honor, this is very similar to the last two, except simpler. These are simply taken from information the Democratic Party produced the discovery that we have again summarized. So all this information is already in the record in an unsummarized form, and we've simply compiled it for the court. What's 280? A lot of this comes from Exhibit 280 from the Goodwin deposition. Cross. In any event, Your Honor, all this information is in the record. We've just summarized it for the court.
All right. Thank you.
And the last two, Your Honor, which I think, I'm sorry, the last two from legislative defendants are 327 and 328 here. I think, if I heard right, these were characterized as demonstratives. Is that right?
Yes.
Your Honor, these were not demonstrating anything that any witness for legislative defendants testified. They didn't put these on the screen for any witness that they had. If I recall right, they put this on the screen for like a minute during Dr. Pegden's cross-examination, but I mean, again, these are just charts prepared by counsel, and I can tell you that some of the information here is just wrong. So I don't know what it's demonstrating. It's not demonstrating any witness's testimony.
Yeah, I believe these were used in the cross and Dr. Pegden, they're demonstratives. It's not that difficult, I don't think.
But Your Honor, the information is just wrong. I don't know, like there was nobody on the stand to explain how these characterizations were come up with, what they mean.
The time to have dealt with that would have been on a redirect to Dr. Hagan, not now.
So, I'm sorry, were they introduced?
They were used on cross with Dr.
They were used on cross.
If legislative defendants had tried to move to admit this at this time, we would have objected. We had no idea they were going to try to move to admit charges that they just unilaterally prepared and put categorizations in. And I guess I've never heard of a party being able to admit a demonstrative that they themselves prepared and used on cross-examination. That would just mean any party could just make up information, use it on cross, and then get it admitted as demonstrative.
All right. Thank you. I think there was an extra page in my group. I don't know whether anybody else. Some copy of an email, or is that?
This is, I think, this is going to be one of the interveners exhibits, so that's
Oh,
one
okay.
objections that were.
All
I
right.
should say we have no objections to the other exhibits.
Yes, okay. All right, so I believe, Mr. Strack, that was all of your, that addressed all of the objections, and then there's no objection to the remaining ones. So we'll take up in a few moments the exhibits that were just objected to. The other exhibits are admitted. The expert reports are admitted for corroborative purposes. Demonstrative exhibits are admitted for illustrative purposes. And we'll address these objections in a few minutes. Okay.
The legislative defense.
Very good, thank you. Interveners?
Your Honor, we have some exhibits we'd like to present as well. These would be intervener defendants exhibits 1 through 12, 14 through 16, 23, 61 through 67, and 98 through 101. We would also like to admit 24, 25 as demonstratives, as well as the designated demonstratives 1 and 2, which were used in connection with Dr. Barber's testimony today. And we are actually not including Exhibit 95.
All right. Any objection from the plaintiffs with respect to that?
No objection.
All right, very good. Any objection from any other party?
Not legislative defendants.
All right. Any further exhibits for this?
Any exhibits for the state? And any further exhibits that we haven't talked about for the plaintiffs?
No, Your
All right. Okay, are there additional matters? So the legislative defense closed. Mr. Branch, you've also closed. The state is also closed. All right. Any rebuttal? We have 10 minutes.
Yeah, we have Dr. No, I'm just kidding. I was going to say Dr. Chen, but then they would have like no rebuttal, Your Honor.
All right. Does anybody wish to be heard in closing in this matter?
Your Honor, it's close to 5. I don't know. We certainly, if the plaintiffs have a closing, we'll give one too, but I don't know that a 5-minute closing would do justice from either side, but we're happy to do whatever plaintiffs want to do.
We'll wait for closing.
All right, that's
Close
fine.
at 5 o'clock.
All right. Okay, well, we do need a few moments just to talk about these exhibits, and so we'll take what remains of the day to do that. So if we'll just be at ease. All right, with respect to the exhibits that were offered by the legislative defendants, we rule as follows. Exhibits 20, 21, 22, the objection is sustained. Exhibit 244, the objection sustained. Exhibit 245, the objection sustained. Exhibits 278, 279, 280, 281, the objection sustained. Exhibits 327 and 328, the objections overruled. Somebody handed us something that says Elmore 14. Is that something you object to, or is that?
No, they removed it from their list.
I see, okay. I thought we had it on our list for the interveners, but 14 through 16, I think were called out, but maybe that's a different 14.
I don't believe there were any objections to the exhibits the intervener sought to introduce.
Okay, including whatever this is.
Yes, I think that might be exhibit 15 from the deposition.
I see.
Intervener defendants exhibit 95, and it's not included in what we are seeking to get into.
All right. Okay, we did need to talk just briefly about what you all intend to submit. I know you, Mr. Farr, I think you said you wanted an opportunity, Mr. Strack, to think about that before you responded to the plaintiff's suggestion that they were intending or suggesting to just submit findings and conclusions. What's your position on that, Mr. Strack?
Your Honor, we've reached an agreement on that. I'll read the agreement into the record, if that's okay. The parties may submit findings of fact and conclusions of law in place of a post-trial brief, but the parties may also submit a post-trial brief of no more than 50 pages. Whatever documents the parties choose to file will be due August 7th. All right, very good. And
so from our point of view, we certainly want, and I think that's what your agreement says, we do want findings and conclusions, but I think we're fine with your agreement that you decide for yourselves whether to submit it.
Can I just add, just to make sure that it's totally clear, our intention is probably just to submit proposed findings and conclusions, and we understand that the defendants may also submit an additional brief, which would be capped at 50 pages.
Right, and that is fine.
that's correct.
That's fine. We're happy with whatever you and your discretion believe is appropriate for us. All right. Any other matters that we need to take up, administrative or otherwise, before we recess? All right. Well, I think I speak for the court to say that we have been very pleased with the orderly, efficient, thorough, and scholarly and well-advocated presentation that all of the lawyers in this room have participated in. It is a pleasure for the court to be able to participate in well-litigated matters, and this certainly has been well-litigated, and we greatly appreciate all of your service to this very important case. So thank you very much for allowing us to participate.
Thank you all.
All right. Bailiff, if you will adjourn us, sign it out.
All rise. Oh, yes, oh, yes, oh, yes. This Honorable Superior Court for the County of Wake, State of North Carolina, is now adjourned. Sine die. God save the state and this honorable court.